Hello, my name is Jesse Lanshe. I'm an attorney practicing in family law and domestic relations. And tonight I'm hosting tonight's show, the Domestic Violence Hotline, on behalf of Arab American Family Services. You are watching an interactive call-in program brought to you live on cable channel CAN TV 21 and online at cantv.org/hotline. During the next 25 minutes, we're going to be discussing the legal aspects of domestic violence as they relate to domestic support obligations, commonly known as maintenance or alimony. And I invite you to call in with your questions. You can reach us at 312-738-1060. Joining me tonight is Martin Ozinski. Martin, thanks for coming on the show.
My pleasure. Thank you for having me.
Why don't you tell us a little bit about your background so the viewers know your experience in this area?
Jesse, I also am a divorce attorney. I practice strictly in divorce and family law. I've been an attorney for about 12 years. I have my own law firm. Before that, I worked with several very reputable firms in the city of Chicago. My main focus area is in Chicago. However, I do have an office in Oak Brook and in Park Ridge, Chicago, so I really encompass the entire geographical area of Chicago. My focus really is with child support cases, divorce cases, maintenance cases, and the like.
I see. Well, thanks for that. Well, today the focus of this show is discussing maintenance, commonly known as alimony, and how that interplays with domestic violence, domestic abuse. Commonly, in most instances, somebody who physically abuses their spouse or significant other is the breadwinner of the family, or in a position to control all the money. So what happens in a situation like that where the abused person doesn't have access to funds to support themselves? Can they petition, or can they seek this for relief from the court?
Jesse, these are very difficult cases, and they're very emotional cases. Like you mentioned, in many cases, the person who is being abused is left without a lot of recourse. They are abused in the home. They don't have access to funds. So their only alternative is to petition the court for protection, for physical safety, and they could also petition the court for some kind of support for themselves and for the minor children, if there are any.
Okay, so if the viewers were watching last month, we talked about orders of protection and the possible remedies that are available in an order of protection. Just so the viewers know, you are not able to seek maintenance or alimony in an emergency order of protection, but in an interim or plenary order of protection, you are allowed to seek from the court maintenance or alimony on a temporary basis. So, Martin, what are the factors that a court would look to determine if maintenance is appropriate in any given instance?
Well, just to begin, the reason why a person cannot obtain maintenance in an emergency order is because the responding party is not in court, and they haven't disclosed their income. They haven't been given opportunity to defend themselves. Once this individual appears in court, and we are aware of what their income is, in that kind of a situation, we can begin to seek some kind of spousal support, some kind of support. The first question is whether the respondent has a duty to support the petitioner. If the parties are unwed, in that kind of a situation, the respondent would not have an obligation to support the petitioner. If the people are married, in that kind of a situation, they would have an obligation, and the court would look at several factors to determine whether maintenance is appropriate.
Does the court only look at the dollars and cents? For example, in a situation where if the husband is the abusing party and the wife is the recipient of the abuse, do they just look and say, well, husband makes X amount of dollars and wife makes Y amount of dollars? Or is it more in-depth of an examination than that?
Well, it is an in-depth examination, and the court really looks at 12 factors, and there are 12 factors that the court would look at to determine whether maintenance is appropriate.
Okay. Going through the list of factors, the first that the court has to examine under Section 504 of the Marriage and Dissolution of Marriage Act. Hold on a second. We do have a caller.
Good evening, gentlemen, and I appreciate you guys having the courage to take my call. But what I want to say, a lot of times when it comes to men, the system is unfair, and I'll be very, very brief, because sometimes when they talk about domestic violence, say if a man, whatever the reason may be, say, okay, I don't want to sleep with her no more. I don't even want to eat her cooking. And they take a lot of the options where a man have. Say, for instance, they don't even want to talk to him, all right? Or even if a man look at them in a mean type of way, guess what? That's domestic violence. But yet, a lot of times, women can say a lot of horrible things to the man, and the system is very biased. It is a double standard, and if a woman don't want to talk, whatever the case may be, guess what? She don't have to talk. But yet we have a court system, a situation that is described in terms of men that stay away from the women, that don't want to eat their cooking, and may not even want to get in discussion with them. But yet we have situations where men are ordered in terms of anger management, and they penalize the men if they're going to have, in those type of situations, they're going to have men going in for anger management. We want to help both parties going instead of all the time coming down hard on the men. And thank you for taking my call, and I wait to listen to your response.
All right. Well, thank you for your call, caller. Certainly, we don't want to give an appearance of sexism on the show, and certainly there are instances where the female in a relationship may abuse the male. Certainly, additionally, this show is primarily about the financial ramifications of domestic violence and maintenance. So certainly, there are instances where the female in the relationship makes more money than the male does. However, we're speaking in generalities, and for our purposes, we are just using as an example instances where a male has been the abuser or the male is predominantly the breadwinner of the family. But just so that everyone is clear out there in the Chicagoland area, certainly, that's not always the case. If you're just joining us, this show is being presented on behalf of Arab American Family Services. Their contact information is listed up on the screen. If you are experiencing a domestic violence situation in your own household, please feel free to reach out to them at the contact information that is provided, and we'll try to show that graphic a couple more times during this show. So, Martin, we were talking previously about the different factors that the court examines in determining whether maintenance is appropriate. And the first of these factors is the income and property of each party. So can you explain to the viewers a little bit about what that means, what the court looks at?
Well, what the court looks at is the abuser's income and the person being abused and what their income is. If the incomes are if there's parity in the incomes, if the incomes are relatively equal, the court may consider that there is really no need for any kind of spousal support. If there's a great discrepancy or any kind of a discrepancy in the incomes, the court would look at that. The court would also look at the assets of the parties. If one party has a substantial amount of assets and if they could support themselves, the court would determine in that case, or the court can determine in that kind of a situation, that the spousal support would not be appropriate because the individual being abused does have an ability to support themselves.
Is it possible, in an instance like that where the court has to look at the property, is it possible for the court to order a person to sell property to get liquid funds to use for support?
Certainly that is possible. Whether the court in a domestic violence situation would do that or not would be up to the judge, but that certainly is possible.
Another factor the court looks at is the present and future earning capacity of each party. Martin, why do you think that the court has to look at both the present and the future earning capacity, and what's the difference?
The present earning capacity is income as of the date of the judgment or as of the decision. Future earning capacity is something that is going to be in the future. And in a lot of cases, we may have one individual that may be retiring. We one individual that may be facing a job loss and their income could substantially decrease in the near future or at some point in the future. I would consider this to be more of a factor considered in a dissolution of marriage scenario versus a domestic violence scenario. In a domestic violence scenario, we're really talking about temporary support, but that certainly would be a factor that the court would look at.
Another thing is the court should look at the roles that each party played during the relationship. For example, the court is directed to look at the time necessary to enable the party seeking maintenance to acquire appropriate education, training, or employment, and whether that party is able to support themselves because they are the custodian of a child. So what do they mean by the time necessary to enable the party to seek their own assistance? Are they considering going back to school and things like that?
Going back to school, retraining, re-education, whatever it would take this individual to reach a level that they may have either had in the past. In a lot of instances, one party stays home with the child, whether it's the male or the female, while the other person pursues their career. In a situation like this, the court would give that individual time to retrain themselves, to bring them back into a position where they could support themselves.
Okay. It looks like we have another caller. Yes, caller, you're on the air.
Gentlemen, please address this. We have, in this county, we have a lot of women that own child support, and somehow they're not really going after them the same way they're going after men. And that's not being addressed at all, because that's another example how the court system in this county is very biased.
Well, thanks for that caller. Martin, have you experienced what the caller is talking about, that the courts are biased against women that owe child support?
I think the court goes equally against men and women. There is a state's attorney's office which prosecutes past due child support cases, and I have in my 12 years of experience, I have never seen them go any less against women than they do against men. Possibly the difference is that women are not prosecuted by men for back child support, but once a matter like this is before the court, the courts are equally aggressive in pursuing funds from women as they are from men, in my experience.
And certainly the viewers out there, if you are experiencing problems, whether it's with a male or female who owes a child support obligation, please reach out to the state's attorney's office or seek independent counsel of your own. Additionally, again, this show is being presented with Association of Arab American Family Services. If you have any domestic violence issues, please reach out to them for further information and further assistance. We have another caller. Caller, you on the air?
Yes. My question is, you just said that the court looks at each case for divorce individually. And if you had a situation where one party wanted to go back to school to learn a skill or something to become employable, assuming that the other party is already working, who pays for that? And is that determined by who it is that wanted the divorce in the first place?
Oh, well, thanks for your question, caller. Let me answer that the second part of that question first, and I'll leave it to Martin to answer the first part. Generally speaking, whether a party is determined to be the petitioner or the respondent in a divorce case, meaning in layman's terms the plaintiff or the defendant, should not have any bearing on the result of the financial matters that the court has to consider. So it shouldn't be viewed as a race to the courthouse and who brings the action first or who's responding to the action. Martin, going to the caller's first part of the question, how would the court look at who was going to be paying for this going back to school type of education?
That is a complex question, and there's a lot of gray areas in the divorce process. This is something that certainly could be negotiated. Possibly it would come out of the maintenance payments themselves. Possibly the person paying for the person paying maintenance would be required to pay for the re-education. What we do is we weigh a lot of different factors. The judge would look at this, and in addition to many other factors, and the court would could order either party to pay for it.
Okay, so it differs on a case-to-case basis.
It does.
If you need some additional information, it would probably be best to reach out to an attorney and seek out a consultation. Another factor that the court considers is the duration of the marriage. Can you tell us what significance does the duration of the marriage play?
Well, if we have a relatively short marriage, the court may consider the maintenance is just not appropriate. The people have not lived together long enough. They have not maybe established enough of a marital estate versus a situation where the parties have been married 20, 30, 40 years and one spouse is severely dependent on the other spouse for income. In that kind of a situation, the court would sway more towards awarding maintenance.
Another factor is any valid agreement of the parties. So what is an instance where the parties might have an agreement with regard to how to treat the financial obligations?
Certainly. There could be a prenuptial agreement, there could be a postnuptial agreement that would specify what kind of payments, if any, one party would pay to the other. If the parties agreed to this before the marriage, going into the marriage, if they entered into some kind of a prenuptial agreement, and in those kinds of situations, we look at what kind of an agreement this was. Was the agreement valid? Was the agreement coerced by one party against the other? And certainly the court would look at that and determine whether a prenuptial agreement or a postnuptial agreement is valid. And if it is valid, the court would certainly give any kind of an agreement that the parties have reached credence in deciding maintenance.
Well, you say you've been practicing for a long time, about 12 years or so, and similarly I've been practicing for about 5 or 6. Recently, in January of 2015, the legislature modified the maintenance statute to provide what they call now guideline maintenance. So, can you give the viewers a little bit of a background as to what the situation was with regard to maintenance before they passed this new statute?
The best way to look at this is by looking at the child support statute. The child support statute is a formula. If there's one child, the payor pays 20% of his net income. 2 children, 28%. 3 children, 32%. Before the enactment of this new maintenance statute, each judge would certainly would look at case law and what other judges decided in the past. However, there was a lot of room for interpretation. One judge may have awarded this amount of maintenance for such and such a duration. Another judge would have, looking at the same or similar circumstances, would have laid down a different type of judgment. So with this new statute, we now have, if the court first finds that maintenance is appropriate, we now have a formula that the court would look at to determine how much a person would pay and the duration. And there's certainly the court could go outside of those guidelines, but those guidelines are very helpful.
So before the enactment of this new law, maintenance awards could differ from county to county and from judge to judge. Is that right?
That's correct.
And you think it was the legislature's intent to provide some sort of uniformity that the parties could rely on, so that it's not so much of a hit or miss situation?
Absolutely. We want everybody to be treated equally in this process, and the one problem that we're going to have, and this is an untried, very new statute, is that that everybody will have to fit into this formula, just as into the old child support formula.
And you mentioned previously that the judges would rely on case law to figure things out. Because of the newness of this statute, there isn't much case law to rely on going forward, is there?
That's correct. Before cases stemming out of this new statute work their way through the courts and the appellate courts, it'll take several months, if not years.
If you're just joining us, the show is being sponsored by Arab American Family Services. Their contact information is being shown on the screen. If you do have a domestic violence situation, please feel free to reach out to them at the contact information provided. Similarly, we are accepting calls. You can call in now to reach us at 312-738-1060. Martin, one of the factors the court considers is the duration of the marriage. Pursuant to this new statute, they set certain ranges for the duration. Can you explain that a little bit further?
Absolutely. So if the court considers that maintenance is appropriate, we look to see how long maintenance would be, how long a person entitled to maintenance would receive maintenance for. If the marriage was from 0 to 5 years, the court multiplies the amount of years by 20%, and that is how long maintenance would be for. If the marriage is from 5 to 10 years, the court would multiply the amount of years by 40%. 10 to 15 years, 60%. 15 to 20 years, 80%. Anything over 20 years, it's in the court's discretion to award permanent maintenance for the duration of the receiving spouse's lifetime.
So going forward, the courts are directed to use a very structured analysis to figure out maintenance and the amount and the duration. Previously, though, the courts would use what was called rehabilitative maintenance or temporary or permanent maintenance. Can you sort of give us the difference between those three?
Well, permanent maintenance is maintenance for the duration of the receiving person's lifetime. Rehabilitative maintenance is maintenance structured to allow the person receiving maintenance to rehabilitate themselves, to return back to school, to obtain a degree, to obtain a recertification, or whatever it would take to get them back into employability. This statute certainly the judges are allowed to go outside of these parameters, but the guidelines do provide a structure for the duration of maintenance.
So even with these guidelines in place, it is possible for the judge to go back to the quote-unquote old-fashioned way of doing things. Is that right?
The courts could certainly go outside of the guidelines in awarding maintenance, yes.
Once the court makes a determination as to the amount and the duration of the maintenance, is it set in stone? Is it that way forever, or can things happen to change the situation?
Absolutely, and this is one of the very interesting things about family law. These matters are modifiable. Unless the court orders permanent, non-modifiable maintenance, certainly this new statute, the way the amount of maintenance payable is calculated is by taking 20%, 30% of the gross income of the payor, and we subtract from that 20% of the gross income of the receiving spouse. Now, 2 years down the line, 3 years down the line, the payor could become incapacitated, they could become unemployed, or for whatever reason, due to the economy, their income could decrease. In that kind of a situation, the payor could certainly apply to the court for modification of support. Likewise, the spouse receiving maintenance could face an uptick in their income, or they could also lose their income. So these numbers that we're talking about are always modifiable.
Similarly, are there events that could transpire to cause maintenance to be terminated for one reason or another? Absolutely.
If the person receiving maintenance passes away, certainly that terminates maintenance. If they cohabitate with someone on a conjugal basis, that would be a reason to terminate maintenance as well.
All right. Well, folks, we're just about out of time. I want to thank you for tuning in. Again, the show has been sponsored by Arab American Family Services, as well as this program has been made possible in part by support from the law firm of Martin Ozinski, LLC, and Lanshe Law, LLC, family law attorneys. Martin, I want to thank you for coming on the show today. You've been very helpful and informative. Do you have any parting thoughts in the next 30 seconds or so?
Well, Jesse, thank you for having me. I would certainly encourage everyone who is facing domestic violence to seek some kind of a remedy, whether it's call the police, that's your first line of defense, apply to obtain an emergency order of protection, do whatever it takes to secure the safety of yourself and your family, and certainly consult with an attorney when it comes to these more complex financial issues.
All right. Well, it's good things to think about, and thanks for being on the show, Martin.
Thank you, Jesse.